I want to give general information about employment law. So I will not advise, because the thing with employment law is every case is different. A little change in circumstances can change the answer of a question. So you will have the chance to ask questions, but I will answer general questions. And some people may think lawyers know it all, but that's not the case. So you may have asked questions and I don't have an answer for you. So, yeah. So, and when I speak, it's general law, but sometimes there are exceptions. For example, in labor law, it's possible to deviate a lot of times in a CLA, for example, but that's too deep to discuss tonight. So I will just give general information, but your particular situation can be different. What are the subjects we are doing tonight? What's an employment agreement? And you would think, why is that relevant? We all know what's an employment agreement, but that's not true, because still there are case law coming from the Supreme Court about the discussion what if that particular situation is an employment agreement, good employee versus good employer, the cycle of temporary contracts, discrimination and gender discrimination. We will speak about discrimination with permanent and temporary employees and part-time and full-time employees. That is new, and that was arranged in the law came into force in 2022. The rights of expecting parents, a lot has changed in that area also in 2022. And I think everybody find it interesting to speak of the end of the employment agreement and what are my rights and how does an employment agreement end. So we will speak, I will, not in detail, but I will just give a little information about how employment agreements can end. The discussion about employment, what is an employment agreement? It's often a discussion about, am I a contractor? Is the person a contractor? We have a assignment agreement, or is the person an employee? And also, I think in St. Martin, there is a lot of seasonal work with tourism. And those confusions about being a contractor and being an employee can arise. And has been, for employment lawyers, it has been interesting the last couple of years on this topic, because there are a couple of Supreme Court cases, and that has to do with the gig economy in Holland, but it's also applicable in St. Martin. Uber, Deliveroo, probably you never heard from Deliveroo, but that's a platform where people would order their food, but that has bring new case law, and it's applicable in St. Martin, and we currently have a case where the discussion is in appeal, where the discussion is it a contractor or is it an employment agreement? And that's the discussion a lot of times with employment agreements. And the law stipulates that when there is salary, work, instruction, and supervision for a certain time, you're speaking about an employment agreement. And salary and work is always the easy one. There is most of the time salary and work, but the discussion is always around supervision or instruction. A lot of times, modern work doesn't require a lot of supervision or a lot of instruction. I mean, I'm an employee and I don't get a lot of supervision or instruction. I do my cases by myself. There are office hours, but nobody really, I have to be at the office, but nobody checks what time I come and what time I go. So you can have a lot of discussion about the instruction and supervision part of it. Um, and the law has a presumption, a certain time, a presumption that if you have worked for 3 months, then there is a presumption that there is an employment agreement. And also in St. Martin, I hear a lot of people say, but we didn't sign anything. I have been working for months there and I don't have an employment agreement. If there is salary, work, and supervision, there is an employment agreement. You don't need a contract on paper. The contract helps because it's proof that there is an employment agreement, but it's not necessarily for a written contract to be made for it to be an employment agreement. And since October 1st, 2022, on request of the employee, the employer is required by law to put in writing that employment agreement. So as an employee, you can go to your employer. I have been working here for some time now. I don't have anything on paper. I want an employment agreement. And it should be in English because I don't understand Dutch. So that is required if the employee asks for that. Another thing I wanted to touch on is in regards to immigration. It happens that people are come to the island to work, and sometimes they are for the papers, they are registered as a managing director of the company. The law clearly stipulates a managing director is never an employee, so that person would not have employee protection. That is also something I wanted to touch on. And as the last thing I want to touch on in regards to this topic, because we have a lot of ground to cover, is the trial period. It happens that there is no employment agreement or there is no written trial period, but a trial period is maximum 2 months, and it should always be agreed in writing. And it's at the start of employment. So if it's not in writing, there is no trial period. So that's also something for employers and employees to take note of. During the trial period, everybody of the employer and employee can decide they want to stop at any time working. So both the employer or the employee can decide, I don't like it here, I'm gone. Also, I wanted to touch on good employer and good employee. That's a legal requirement. In the law, it's stated employers have to behave as good employers towards their employees. Employees have to behave as good employees towards their employer. And a lot of you maybe are here because they want to know rights and obligations, but the law is a framework in which we operate, the labor law. So employeeship is of the relationship between employer and employee is a long-lasting relationship. And the case law says a lot of good employer and good employee, but every case is different. And I think sometimes employers and employees forget that, we have to be reasonable with each other because we need each other. The employer needs the employee to produce. So the organization get to his goals, but employees also need the employer because the employer pays a salary and the family can eat, or it gives a sense of purpose to have a job. So I think a lot of times people forget their common sense. I have rights, you have obligations, but if everybody is more reasonable with each other, we will go a long end. So yes, law is a framework, but just think and use your common sense and be reasonable for both sides. That would help. Less people would end up in my office if that would be the case. Yeah. Another topic that may be of interest for a lot of people is the cycle of temporary contracts. And that has changed since 2022. It used to be 3 contracts or 3 years of 36 months. But since 2022, it's 2 contracts or a maximum of 24 months. So if you do 2 contracts of 6 months, the third contract you give the employee for 6 months, the employee would be permanent. Or after 24 months, maybe 2 contracts of 1 year, the third year, the employee would be permanent. And the temporary contracts end by operation of the law. You don't have to give notice unless it's agreed that you will give notice. And it's nice to tell the employee, or that the employee tells the employer maybe a month in before, hey, we're not extending the agreement. Hey, I'm not want to stay working here the next year. But it's not required. You can technically, the day before the agreement ends, you can say, hey, we're not renewing, don't come tomorrow, unless otherwise agreed. 3 months, a gap of 3 months breaks the cycle of contracts. So if the employee has been working 24 months, and then it's decided, okay, maybe we don't need you anymore. If the employee stays out 3 months, then the cycle starts again. And it's not a good thing. I think I had the revolving door, and that can be a problem. Okay, you work 2 years, you go out for 3 months, you come back, you work 3 years. That can be a problem, and there is case law about it. But in principle, 3 months will start the cycle over new. And yes, and the 2 contracts, maybe 1 year, the next day after the 2 year, the employee comes in, start working, he is permanent. So, yes. One of the topics I think I like that it was introduced, but it's very difficult to do something about it in practice, is discrimination. And we're speaking about discrimination between men and women, gender discrimination. And it's into entering into an employment agreement. If you don't enter into an employment agreement because somebody is pregnant, that's discrimination. That's not allowed. But we all know if you show up with a belly, you will not get a job. We know that, but it's not okay. It's not legally allowed. So it's very difficult to prove in that situation. There's a case in Curacao. I think somebody was working for a company, and then she got pregnant. She would receive a permanent agreement, and they told her, because you're pregnant, you're not getting the job. Yeah, wrong. Most of the time, you wouldn't know, but that can be a problem. Also, during employment, everything that causes discrimination between gender is not allowed. Schooling, employment conditions, employment circumstances, promotions, termination of the employment agreement because somebody is from a gender or another is not allowed. And there are exceptions, which everything it's exception. There are exceptions. Maybe a man is better suited physically for a certain job, or maybe a woman is suited physically better for a certain job. So those kind of exceptions can be there, but it has to be justifiable. One part of the gender discrimination in the law is also the sexual harassment, and I have specifically a woman harassing a man because that happens. We always think sexual harassment is woman harassing men, but it can be in all forms of shapes. Um, that's also part of sexual of gender discrimination, and it's very broad. It's very broad described in the law, so it's not only touching, but it's all form of verbal, non-verbal, of physical conduct with a sexual connotation, which has as its objective of consequence that the dignity of a person is affected, in particular if it's threatening, hostile, abusive, or humiliating, or a harmful situation is created. So that's very broad. The jokes, the sexual jokes that I think sometimes are done in companies or in organizations that everybody laugh about but feel uncomfortable about it. Yes, it's not okay. So, and legally, if it creates if it creates a hostile, abusive, humiliating, or harmful situation, the employer should do something about it. And there are consequences for the employer if they don't do anything about the situation. Gender discrimination, sexual harassment in their company. There is a reverse burden of proof. If, for example, a person or employee shows in a court case, ex-colleague has the same amount of years working as I, we do the same job, there is no difference between us, but that is explainable, but he earns 2,000 guilders more than me, and with no kind of explanation, or that can be a reason of that. The burden of proof is then on the employer to show that there is no discrimination, that the gentleman or the lady is not paid more because of his gender. So, and the court can order the employer to remove the disadvantage, and that can be costly if with retroactive active effect, the court says, hey, you have been paying somebody, there is discrimination, you have been paying somebody less for the same job, same experience, same everything, and there is gender discrimination, you should make sure that the lady or the gentleman earns the same since X period. So that can have consequences. And if the gender discrimination leads to a dismissal, the employee could ask for annulment of the dismissal based on discrimination. The other forms of discrimination that are in the law since 2022, or that became applicable, is permanent and temporary. I think we experience in St. Martin sometimes that the permanent employee is treated in another way than the temporary employees. They will have less benefits. They will have, just because they have temporary. All permanent employees have something and the temporary employee doesn't have it. That's not legally allowed. Also, the discrepancy with full-time and part-time employees, that's also not legally allowed unless you have reasons. I mean, it is possible that a person is working or working for a longer time, that they need to be compensated more, or you have to have a good reason why you make the difference between permanent and temporary employees. even neutral provisions, a standard course of action. Maybe part-time employees are never invited to the Christmas dinner. That's possible. That's neutral or neutral provisions. Sometimes I create employment agreements and I put a neutral provision in, but it can lead to discrimination because you use the new agreement with all the new employees, the temporary employees, and all the permanent employees have another agreement. So that can sometimes lead to discrimination. Even if it wasn't the intention, you just created a new template, but you have to be careful about that as an employer. And as an employee, if you see that all the permanent full-time employees get a bonus and you as a part-time don't get it, maybe it's the moment to say something about that. The consequences, if this discrimination leads to end of the employment agreement, of complaining about the discrimination leads to the end of the employment agreement, the employee can annul the dismissal, or the courts can order the employer to take away the disadvantage caused by the discrimination. And then I don't know how controversial this picture may be in St. Martin, but that is a parliamentary in, I think, New Zealand or Australia that was breastfeeding her child to make a point. So in Parliament, yes. Since 2022, there are a lot of extra rights, written rights for mothers, but also for fathers. That's a good thing. One of the new maternity leave became more, and the maternity leave has to be taken 8 to 2 weeks before the expected date of birth of the child, and its maternity leave is divided between two: the maternity leave and the leave after the child is born. And the leave after the child is born is at least 7 weeks. In total, it should be 16 weeks, but if the child is born later than expected, and you took most of it before, then it should last at least 7 weeks after the actual date of birth. And I think maybe not known for a lot of men, but paternity leave, fathers can take 7 days to be taken between 2 weeks before or 7 weeks after birth. So it can be arranged in a way with the employer. It can be half days, but fathers are entitled to this. So now you know, and the next time your partner is having a child, you know that you can ask for paternity leave. Limitation of night shifts for heavily pregnant employees. That's also new. No night shifts for 8 weeks before the planned date to give birth, and with the doctor's notes, it can be limited even further. And after the birth of the child, 4 weeks, no night shifts. Limitation of the standing work for pregnant women. 12 weeks before giving birth, a woman cannot be required to do standing work for more than 60 minutes at a time. So they are entitled to rest. Also, a new one, till 9 months after birth, the woman employee has the right to use 1/4 of their working time paid to breastfeed or to pump. And This is also a good one because women doesn't have to go to the toilet to pump anymore. The employer has to provide a place to breastfeed, a suitable place, not in the toilet. Yes. So, and a suitable place is also a place that can be closed off and that the woman has privacy. So, then we come to the end of the employment. We have a closed system of how employment can end in our legal system. There are only 4 ways an employment agreement can end. Dismissal or quitting for urgent reasons, and we always hear that the employer dismisses the employee for urgent reasons, but the employee also can leave the job for urgent reasons. Giving notice, that is, both parties can give notice. Dissolution by the court. We also always hear that the employer takes the employee to court to dissolve the employment agreement, but the employee also can take the employer to court to dissolve the employment agreement. And mutual agreements. That's the 4 that the law knows. Your employment generally cannot end in any other way than these 4 ways. Dismissal for urgent reasons. There must be an urgent reason. There must be a reason where the employment cannot last for any longer. And the law gives all kinds of examples, stealing, violence, but they are examples. So it may be possible that in a certain company, certain rules are very strict. For example, stealing, in certain companies, getting Coke out of the fridge, and we have it a lot in Holland, I think, KLM and those, getting a Coke or getting peanuts, or there is also case law in which stealing in a company is defined of getting anything. So even something that is thrown away, you take it home. That may be stealing if it's arranged like that in your company. But it's always all circumstances are involved. The case law is very strict about stealing, but if when weighing an urgent reason, as a lawyer, you don't know. Sometimes I just know this is not an urgent reason, but sometimes you don't know because it's the tenure of the employee. It's how long the employee was there. Was it a great employee? Was it a bad employee? Where the evaluation is that there's an isolated incident, so it's very difficult to know sometimes when it's an urgent reason. And an urgent reason is always immediate. So it can immediate in the sense that when you discover it as an employer or something happened in an employee, you cannot sit and wait 3 weeks, 4 weeks, 5 weeks, and I think the employee has to go. It's immediate. Sometimes you have to send the employee home for a investigation. That's possible. Sometimes you have to check video cameras, speak to other witnesses, but it should happen as soon as possible. And sometimes it can take a while because there needs to be a forensic investigation, but as soon as possible. And you need to hear the employee. Employee needs to tell the employer clearly why there is an urgent reason. So if you don't hear the employee, you don't tell him, I'm thinking of dismissing you for urgent reason because XYZ, then the employment, then the employee would have good chances to annul the dismissal. So always hear the employee make a report about that, and yeah, make sure that that happens. And employees, if that didn't happen, if you were just dismissed for urgent reasons and there was no conversation, you weren't even invited, you just got a letter, or they told you, don't come back tomorrow, what happens? I don't, without you knowing what it was, then probably the urgent reason will not stand in court. So it's very important for employers to get good legal advice before they dismiss employees for urgent reasons, and it's an ultimate remedium. So it's not something to be taken lightly. Notice. Yes, an employee doesn't need I put valid reason. An employee doesn't need valid reasons. They can just give notice, and the notice period for an employee is always 1 month unless otherwise agreed. And if otherwise agreed that the notice period for the employee is more than 1 month, then for the employer it should be double. So if in your employment agreement it's written as an employee, your notice period is 2 months, 3 months, 2 months, for the employer it's 4 months. 3 months for you, for the employer is 6 months. And the employer will always need, in most circumstances, will need a permit from the labor office before they give notice. And there are some exceptions of employees for which no permit is needed, but those examples are very little employees. I expect employees that have a labor agreement with government, teaching personnel at a teaching institution, household personnel, and persons that work in a clerical role like a priest. For those people, you don't need a permit, but you still need, as an employer, a valid reason to dismiss them. And it can be the performance. You tried in many ways to have the employee performing well, but the employee doesn't perform. Financial circumstances, and for each of one, there are certain rules, but reorganization, region pension age, all of those can be valid reasons, but they need to be substantiated. And also in that case, a notice period is applicable. And if when you get the permit, you have a notice period to use the permit. You have you have to give notice, and you have to take a notice period into account. And most of the time, if the reason is not caused by the employee, severance. I don't know if cesantía is something you have heard about. Cesantía is due unless the end of the employment was caused by the employee. It's not possible to give notice in the first year of sickness unless the employee has not been complying with integration measures, following doctor instruction to get better. And also, it's not possible to give notice to an employee that is pregnant. The dissolution by the court, also this one needs to be substantiated. And it can be for a change of circumstances or for urgent reason. And in that case, you submit a petition to the court. You say, I want this employment agreement to be dissolved. That can be the employer, that can be the employee, because X, Y, Z, and you substantiate it with documents. And the court will assess the reason brought forward for the end of the employment, and there will be a court decision in which the employment is dissolved or not. And and the severance is decided then by the court, depending on the circumstances, and they have a special formula, but the court is very free in weighing all circumstances. And a lot of times we end up settling also in court cases like this. And there will not be a court decision, just a settlement. And the good thing about the solutions is that it's final. So as lawyers, we like this because there are not a great possibility of appeal. You can only appeal a court decision in a dissolution case if the court has failed to use the law right of to, for example, they didn't hear both parties before they decided. There has have to be a great misjustice, and not in normal cases you cannot appeal the decision in dissolution cases. And the settlement agreement, that's also very liked by lawyers. It's a clean way to part ways, and it's a result of just proposing, accepting, negotiation between parties without too much costs, because going to court is very expensive. Yes, if an employer proposes a settlement agreement, they should always give the employee time to think about it, to consult a lawyer, because if they don't do that, I think it happens sometimes. A settlement agreement is presented and with the idea, sign now, agree now, and that's not a good way to do it, because it can be annulled if the employer put a lot of pressure and didn't give enough time to the employee to think about it or to get advice. And with that, I think I told you all what I wanted to tell you tonight. So feel free to ask questions, but we will do it one at a time. And remember, not your particular situation. I cannot give legal advice, just general questions.